Before we move on to criminal procedure, let's handle a few questions which deal with general principles of criminal law. The first of these is question 17. A person is not responsible for criminal conduct if, at the time of such conduct, as a result of mental disease or defect, he lacks substantial capacity to either appreciate the wrongfulness of his conduct or to conform his conduct with the requirements of the law. This quotation is basically a statement of the D Model Penal Code provision. D is the best response because the language in it mirrors the Model Penal Code approach to insanity. It's actually a direct quote. The Model Penal Code requires that defendant have a mental defect such that he lacked the substantial, not total, capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the law. In essence, this relies on or combines the irresistible impulse and McNaughton. This is a hard question for many applicants because it calls for a definition of a term. There's no application for facts. Anyhow, D correctly identifies the type of insanity test quoted in the question, so it's correct. A is wrong because the definition given doesn't define the McNaughton rule. B is incorrect because the test quoted has somewhat different coverage than right or wrong plus irresistible impulse. It's true that some jurisdictions do use both the McNaughton and irresistible impulse tests and acquit the defendant if he meets either test. The quote in this question would not represent a combination of the two tests, so B is wrong. Finally, C is incorrect because the Durham rule only requires that the crime be the product of a mental disease or defect. The best answer to question 17 is D. Now let's have a look at question 18. Dexter, a physician, and Caroline, his patient, had sexual intercourse in his office. Caroline is a married woman, and if charged with the crime of adultery, her best defense would be which of the following? Answer: D is the best response. Dexter induced her to believe he was using a medical instrument. D is right because it offers a defense which negates one of the elements of adultery. Typically, adultery requires that the defendant have sexual intercourse with someone other than his or her spouse, and that the behavior is open and notorious, and either the person is married or he is single and knows that the other person is married. Mistake of fact is a valid defense where it negates the necessary mens rea. Caroline's belief that Dexter was not having sex with her, but was only using a medical instrument, would negate the knowledge element of adultery. Since D cites a defense which would likely succeed, it's the best response. A is not the best answer because, as a crime, the forgiveness of her husband would not exonerate Caroline of criminal liability for adultery, and thus it's not her best defense. B is wrong because the mistake it cites would not exonerate Caroline of liability for adultery, so it isn't the best defense. Caroline's belief that sex would be a cure for her condition would not negate any of the elements of adultery, since the key mental element, that she realizes she is married and Dexter is not her husband, is not changed by her belief that sex will cure her condition. C is wrong because the mistake it cites would not exonerate Caroline of liability for adultery, so it is not her best defense. Here, Caroline's rather outrageous belief that she is pregnant and Dexter could perform an abortion through sexual intercourse would not exonerate her. It does not negate any of the elements of adultery. The best answer to question 18 is D. Our next couple of questions are questions 19 and 20. They are based on a brief statute about vehicular manslaughter. Whoever in the course of driving a motor vehicle as defined in the code is criminally negligent in driving such vehicle or omits to do anything that it is his duty to do and shows a wanton and reckless disregard for the safety of other persons and, as a result of such act or omission, causes the death of a human being, is guilty of vehicular manslaughter. Vehicular manslaughter is punishable by a sentence of not more than 10 years in the state prison or 1 year in county jail. The first question we've got to deal with is 19. Defendant, driving alone at a reasonable rate of speed, was disturbed by a child carrying a silver balloon. He went through a boulevard stoplight and killed a pedestrian. He is charged with vehicular manslaughter. Of the following proposed definitions of criminal negligence, which is the most favorable to the defendant? Answer C. To find the defendant guilty of criminal negligence, the jury must find as a fact that he intentionally did something he should not have done, or intentionally failed to do something which he should have done under circumstances that demonstrate a conscious disregard of a known danger that his conduct would produce the result which it did produce. C is the best answer because it introduces the strongest subjective element into the definition of criminal negligence. Here, the question is asking us for the most favorable definition from the perspective of the defendant, not the most reasonable or the best definition. So the way to determine this is to identify the response which creates the most difficult standard for the prosecution to meet, since that's the standard which defendant most likely will be exonerated. In order to do that, you should identify the standard which has the strongest subjective element, and that is pick C. By stating that criminal negligence requires the defendant to intentionally do something he shouldn't have done, or intentionally fail to do something he should have done, indicating a conscious disregard of a known danger, option C makes it unlikely that defendant will be convicted, since while his behavior probably was objectively negligent, he also probably did not consciously disregard a known danger. Now, it may seem a little odd to have a strong subjective element in negligence, since negligence in tort is judged purely subjectively. Some states do use a subjective standard in determining criminal negligence, so it's not completely unheard of. Because C identifies the negligence standard that will be most difficult for the prosecutor to meet, of these four picks, it's the best definition for the defendant, and thus it's the best answer. A is not the best answer because it doesn't offer a definition that helps the defendant very much. All it does is states that criminal negligence is something more than slight negligence. That leaves defendant open to liability. Clearly, the defendant did disregard the consequences of his act. He wasn't watching where he was going, and he did display at least some display of indifference to the rights of others. Because defendant most likely would get convicted under option A's definition, it isn't the definition that's most favorable to him, and as a result, it's the wrong pick to question 19. B is wrong because it also isn't favorable to the defendant. And D is wrong because it too offers a definition under which the defendant is likely to be convicted. The best thing for a defendant is to offer a definition which includes a strong subjective element, because it's obvious that the defendant clearly didn't intend to kill the pedestrian. Because D's definition isn't really strong when you looked at it from the defendant's point of view, it isn't the best answer. C is the best response to question 19.